Well, we got another document to take a look through. Contemporary slavery and its definition in law. You can find it online using that term or that search operator. So highlighted a few spots like I did in a prior example or in one of the prior clips that I put together earlier. So what we're going to do here is look as basically we try to come to terms on what slavery means and what's been done in law in regards to slavery. Some of you might want to hang around as we get deeper and deeper into this. There's a pretty good conversation in the difference between de jure and de facto. So let's go ahead and take a look through this and see how things have come together over the years in the area of slavery, or what's now termed more conditions like slavery. So the definition found in 1926 from a convention, slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership is exercised. So it doesn't say much, as it even admits right there, but it appears that it requires a person own another. But in reality, that's not exactly the case, because as it says, it has been legislated out of existence. Ownership of one person over another is no longer legally possible. So slavery, in the view of the law, has been legislated out of existence. So we're going to go ahead and look through different conventions and documents and treaties that have come together in order to discuss that. So thus we know the definition holds, but do we really know what the definition stands for? What is slavery anymore? So here it's a legal tool and this was the reason for trying to define slavery or conditions like slavery, is to be a legal tool to assist prosecutors of individuals that are involved in enslaving others. It's also as an advocacy tool meant to aid in bringing contemporary slavery to the forefront of the public consciousness. That's probably the reason that I would want to share this clip with you, is bringing slavery, contemporary slavery, the way it's practiced today, to the forefront of our minds in an attempt to suppress slavery and help those of us that are suffering from slavery or conditions like slavery. So they basically, what we're going to do is they start off with a current definition and they build backwards. So the definition can be translated so as to both reflect the lives experienced of slaves, and to provide legal parameters so we can give the term slavery some legal certainty. So they're trying to make this concrete, if you will, from a legal aspect. So in other words, we want to be able to read the definition and then apply it. So as we go through the definition, I hope that bringing this to public consciousness, that you might be aware of how it might be practiced in this day and age. In setting out this chapter, it's going to read like a how-to manual, giving the reader the ability to understand what slavery means in legal terms, and if need be, to follow its genealogy backwards to get better understanding. So, here they talked about they were working on this as recent as 2010 and 2012, and I'm sure there's been more areas as well. And they developed a Bellagio-Harvard guideline on the legal parameters of slavery. So it's not something that's totally gone, it's something that's current today. And so in working on that, they showed that the property paradigm from 1926, which was one of the earlier conventions, that definition does in fact capture the essence of slavery, be it contemporary or otherwise. So it's worth repeating the definition of slavery from back then. Slavery is the status or condition of a person over whom that's any of the powers. That means it doesn't have to be all of the powers, but any of these powers that will be discussed later are attached to the right of ownership. So the parameters of what was and was not to be considered slavery should become evident as we go through this. So ultimately, what we object to in slavery is the inability of a person to exercise their natural capacities when they find themselves in a state of unlimited subordination to another individual. So the green obviously has a little bit more value, so I used green, at least in my perspective. And then we're going to go ahead and see the pink here in a moment, which has even more value from my perspective. So the link between property paradigm and slavery is in a word, control. So instead of using, somebody being owned or actually legally owned as if somebody has a title or a claim against them, it has to do with control of them more so than ownership of them. So it's normally understood, control is also normally understood as possession. So if you're in possession of something or in control, if you're in control of something, you are said to possess it. So as an example, if you have a key to your house, you're in control of the items inside the house. They're considered to be part of your possessions. So with that in mind, slavery should be understood as the ability of one person to control another as they would possess a thing. So being able to lock it up inside a place where it's secure is the type of control and possession that is tantamount to conditions like slavery. So, and that's where it says here in pink. Control is tantamount to possession. So if you're in control of something, then you are said to possess it. And possession leads towards, again, the ability to subordinate another individual. It is control exercised in such a manner as to significantly deprive that person of their individual liberty. So if your liberties are being thwarted and it's done by an exercise of control, that is in effect what conditions like slavery in the contemporary era are defined as. Normally, this control is exercised through violence. So if it has to do with somebody having a gun at your head or through threats of violence or coercion, but it also may emerge through deception and or coercion. So if somebody's frauding you, tricking you, deceiving you, and therefore still controlling you, then deception as well as coercion, as well as violence, are normal forms of exercising control, and control is tantamount to possession. Possession would be ownership, and therefore a condition like slavery. So control tantamount to possession of a person goes beyond physical control. They don't just have to have your body. They got to, again, if they're working through deception or coercion or threats, that works as well. So slavery can only be present if possession is present. If control tantamount to possession is being exercised. So you can look at that backwards. If control equal to possession or possession, which is through control, is present, then slavery is present. And so that was basically part of what was worked out in those Bellagio Harvard guidelines. So what then are the other powers attaching to the right of ownership? To involve a person as the object of a transaction may provide evidence of a slavery. So transactions are huge. Each and every transaction, if a person is basically controlled in that transaction or possessed within the transaction, then that might be evidence like slavery. So it says right after that in the unhighlighted area that it may provide evidence of slavery, which is to infer that it might not. But let's go ahead and look at this. It's sometimes said that athletes are slaves because they're bought and sold. But it may be true that their services are bought and sold. Basically, they can walk away. They don't have to continue in it. But in cases of slavery, somebody or something or some entity is exercising control in such a manner as to significantly deprive the enslaved of their individual liberty. The person or entity enslaving is dictating what the enslaved is to do and backing up this dicta with violence, either actual or latent. So dictating, dicta, those words seem to fall right in the middle of jurisdiction. Juris is to judge. Dicta, as you can tell here, is dictating or word. So jurisdiction is judgment of the word. So again, in a transaction between parties, if somebody has jurisdiction, then that person or that entity is enslaving them through control of the dicta, either actual or latent. So what is required to establish whether control tantamount to possession is present? The same would be true where other such transactions involving human beings are concerned, such as bartering, exchanging, or gifting a person to another. So I'm curious here if that might apply to parens patriae, which means the state is father, and the current state of family court. If one party goes to the court who can take jurisdiction, would the children and the parties become part of a transaction? Would those children or those offspring being considered human beings? Are they being exchanged or gifted from a person to another? Is that applicable there? We'll have to see later as we get into this, but the whole concept of exchanges and transactions and gifting and exchanging persons in a transaction may provide evidence of slavery. So especially if there's some threats or coercion that is being used, or again, fraud, and so on and so forth. By using a person, and that's another thing. Nevertheless, such use may amount to slavery if the background relationship of control is present. So if you think about that, if there's been a long-term relationship or some background of a relationship, the use of that relationship or the use of a person through that relationship may be tantamount to possession. So by using a person, what is meant is the deriving of benefit from his or her service or labor. So the use of a person is the ability to manage the use of a person. So again, if we look at transactions and exchanges where one person or human being is being exchanged to another with the ability to manage the use of a person or use the person in and of themselves. So, in parens patriae, if the father is state and the father is acting to dispossess one parent to give another parent the right and then create a debt, is that somehow the ability to manage the use of the person? Not just the child, but under parens patriae, once the court takes jurisdiction in the case, they have control over all the parties involved and therefore become responsible for managing the use of the person. So within the context of sex, it may also include more abstract management. So that's the key part there. It may also include more abstract management, where a person manages the use of a slave by isolating them from their previous social relationships and forging a new identity of that person through the compelling of a new religion, language, or place of residence, and or even their marriage. So does the state somehow, some way, somehow become responsible for managing the persons? Do they do that by forging new identities of the person? Do they compel new religions like parens patriae, where the state is father instead of potentially a creator? Do they force you into acknowledging and honoring their considerations towards what's real and not allow you to practice your own worship? Do they give you another language and force you into another language? Many of us use common language between us, and legalese is the definitions of terms like slavery and conditions like slavery in order to force us into a language that we might not be competent in, thus requiring some other party to take part in the transaction and help us to contemplate the language. Can you be forced into a place of residence and or even marriage? So if these things are controlled in any way whatsoever by being managed by some entity, these are abstract management concepts that are involved with conditions like slavery. Another thing to look at is the next highlight here, profiting from the use of a person. Many people have been up in arms over the taxation of their efforts, their wages. It's as if you reap and somebody else sows a portion of this. And so profiting from the use of a person. So this is where once control tantamount to possession has been established over a person, money can be made from his or her use. This can be applied to people that are working at this point in time for wages and basically the taxation system is making money for somebody else who has established control, tantamount to possession. But could this also be said to all of the men that are, or women that are going into jail or prison for a debt created by the state, and the state needs to make that money from them or off of or use them in order to make revenue? So it might also entail the mortgaging of a person. So again, being let for profit or being used as collateral. So the collateralization of a man and binding him to a person in order to take that man as surety for a debt is some of these same areas that fall in this document of conditions like slavery. So in concrete terms, so this is solid, this would mean that a slave is used and the money received from the toil of that slave, either his or her salary or the product of his or her labor, goes to the person who has enslaved. So again, think about the definition of person. It is an individual, it is a corporation, it is body and body's politic. So there are multiple meanings in the legal sense of what a person is. And if we use the legal definition of person here, it would certainly be applicable to state and government entities. So to get down further, the profit from that labor, along with the salary that was meant to go to the worker, is appropriated. Further power, thought to be less common, is to transfer a person to an heir or successor. Is this not the same thing that's happening when somehow a court, which is again a representative of the state, an instrumentality of the state, thus a person, are they able to transfer a person to a successor or somebody else? Is this not what happens when children become wards of the court and then eventually get placed back into custody? Custody is a word for control or possession, not ownership. So this is a further power. It's thought to be less common, yet in reality, it fits into the property paradigm, and that is actually way more common, and that's why they point out that it's thought to be less common. In the language of property law, it is said that ownership is the ability to use up property, to exhaust a thing, to consume it. Now here, interesting, it says you can use a car, and you can exhaust a pack mule, and you can consume food. These are all consumable goods, something that goes along with your private property rights. Now, I just did a recent presentation on how the automobile or the car is called consumable goods. And it says, again, that you have the right to use it and even destroy it if you'd like, just as much as you can do the same thing with food. It may be understood in relation to the disposal, the mistreatment, or the neglect of a person. So if it's possible for an entity to dispose, mistreat, or neglect a person, these situations could also tie in as part of the any category within the all of conditions like slavery. So can this be done? Some of the ways that this might be done is by severe physical or psychological exhaustion. Are you tired of what's going on? Are you tired of the mind games? Well, this is another way that they can attack the well-being of a person and in effect destroy or mistreat or neglect. It doesn't just have to be physically, it can also be done psychologically. The person is broken, and over time they grow frail, either in body and mind. So it's as if the attacks keep coming and keep coming and keep coming and keep coming, as again some of that psychological deception and fraud that leads to the breaking down of a person, so they can become basically controlled or possessed, tantamount to slavery. So here they even get down there, the attempt by the state to expropriate. Expropriate is a word we hope to look at in the future. Will not mean that the exploitation is not allowed. So attempt by the state to expropriate will not mean that expropriation is not allowed, rather that there is due process, a public interest, and that fair market value compensation will be provided. So it's as if the state can expropriate if there's due process. Isn't that the one thing that is said to be given to everybody as a right, is due process? So as long as you go through due process, the state is capable of expropriating, especially if it's done for a public interest, and that a fair and market value is provided. And this compensation is that due process. So ownership of slaves is no longer protected from expropriation by the state. So the state cannot then take over the deed of ownership of a person. The state is not supposed to be able to take over a deed of ownership of a person. Yet that's exactly what is happening when it comes down to involvement within, I believe, the family court system. Instead, they want to get into this concept of insecurity of holding, which is the duty of a state to expropriate. See, they've created a duty on the state to expropriate, to confiscate human beings held in situations tantamount to possession. And they even say as if to liberate them. Well, if you go from being held by one captor or one enslaver, and the state comes and expropriates you and confiscates you because you're being held in tantamount to possession, but if they don't liberate you, how is that any different? So having set out the various powers, so again, the various powers we've just discussed, one can get a sense of what will constitute slavery in the law. So including buying, selling, these stand by themselves. It doesn't have to be all, it's any. Buying, selling, using, managing, or profiting, and even the destruction of another person. It would be important to evaluate the specific circumstances and not make judgment based on what the specific practice might be called. And what they're getting to here is, if you want to use the term slavery, we don't want to say just because that word is no longer viable that it isn't slavery. Instead, we need to look at the practices and the circumstances that are going on to see if it might be applicable. So they tell you right here, certain terms, such as slavery and practices similar to slavery, are terms of law, where other terms, such as contemporary forms of slavery and slavery-like practices, are terms of art which have no legal currency. So that's an important area to understand right quick. You might recall that during the campaign to get Trump out of office, they kept saying that he was responsible for collusion or colluding with Russia. And Trump jumped on that word collusion over and over and over. There is no collusion, collusion, and collusion. Because collusion is a term of art. It has no legal currency. You cannot be charged for collusion. The term of law is conspiracy. And conspiracy to work with another to create crime is in effect the same meaning as collusion. Colluding with another to fraud and cause crime. But see, only terms of law are applicable within the legal system, where a term of art has no value. So Trump jumped on collusion right away because it was a term of art and he couldn't be charged under law for collusion. It would have been the term conspiracy. So this is the same thing that's going on in the legal system today with terms of art and terms of law, where it comes to the word slavery. Slavery, as it says, and practices similar to slavery are terms of law, and they use all these other terms of art, which have no legal currency. So simply ask, in green, is there any exercise of any of the powers attaching to the right of ownership? So if there isn't any power, if there isn't any use of any of these powers attaching to ownership, then it wouldn't be slavery as a term of law. But if it is practices similar to slavery, then it would be have legal currency. And it doesn't have to be all. Again, it says any of the powers. It may be best to start looking and ask whether any or all of the powers, there it is again, they say it all the time, any or all of the powers are exercised. If so, then slavery is present. So again, it's telling us right here, it may be best to start looking and ask whether any and all of the powers are exercised. If so, then slavery is present. So they have other terms that came about in other conventions where they established the term forced or compulsory labor. That shall mean all work or service that is exacted from any person under the menace of a penalty, and for which said person has not offered himself voluntarily. So this in the Constitution in Michigan is listed as involuntary servitude shall be prohibited or not allowed. And so forced or compulsory labor basically means all work or service that is exacted from any person under the menace of a penalty, where the person has not offered themselves voluntarily. So if you haven't volunteered, if you haven't consented, if you haven't subscribed, if you haven't been willing to be a part of it, and they want to force you to work, this is compulsory labor. And again, if they did not offer themselves voluntarily, then this will, in law, constitute forced labor. So they've got other terms. Forced labor, involuntary servitude, is as much a crime against the Constitution in Michigan as in slavery, or again, practices similar to slavery. So as between slavery and debt bondage, serfdom, servile marriage, or child exploitation, all of these things are part of conventions to where these things are as unconstitutional or against the law of the land as practices similar to slavery. They've just defined them differently, but they do have debt bondage, and the Michigan Constitution again points out that there shall be no debtor's prison. And so child exploitation is another area. Serfdom as well has been defined in other conventions and brought into play here too. Reference would then be made to the definition of those conventional servitudes. See, conventional servitudes are common and have been discussed in the past in light of what slavery would mean. So we can move down further. Does the definition only apply to situations of chattel slavery, or historical types of slavery where one owns de jure a slave? So here, de jure enslavement is, in other words, ownership in a legal sense. So this is where I wanted to talk and highlight that we get a little bit into the difference between de jure and de facto. De jure is, in other words, ownership in a legal sense. It's what's being done within the legal system. So in the definition of slavery was only applicable in the past to de jure in the legal system and not to de facto situations of ownership. So, however, we're going to see that one can exercise the power without actually owning in the legal sense. And that's really where we're talking about de facto. Is it doesn't have to be written legally in a legal sense, de jure in other words, but if it's actually being done without the legal sense, then it can be considered the de facto. So de facto situations of ownership then would have little contemporary relevance, and thus elaboration of the content of powers attaching to it would be moot. But that's not the case, because they've moved forward and shown, however, that one can exercise the power that attaches without actually owning in the legal sense. And that, through this convention, basically allowed for an interpretation that gives contemporary relevance. That means today, things can be done or are being done in a de facto status, which would be contrary to law, even though it's not legally contemplated as contrary. So hope this helps clear a little bit on the de facto and de jure understandings, because it does give contemporary relevance. So the definition reads, and this is out of a 1998 court case, or convention where the Rome Statute came out. The definite enslavement means the exercise of any or all of the powers attaching to the right of ownership over a person, and includes such powers in the course of trafficking persons, in particularly women and children. Now, this this might be thought to be still happening today when we look at, again, a man's rights to his offspring in relation to marriage certificates considered a legal binding of the two parties under the power of the state, or the illegitimacy of a child, or offspring, if the man doesn't have that legal license to produce children with that woman. So again, they point out that particularly the women and the children are a focused effort. And I think that this practice still runs today in the nature of what we see on the birth certificates, and for the people that have studied those, and also what's going on within the courts as far as the standing of a man when it comes to legitimacy or illegitimate offspring. So it is a common legislative tool used by judges and prosecutors and so on in cases of trafficking to those instances where women and children may be involved. So they've carried this forward throughout time. This is in the document. I encourage you to go ahead and read it. Down here in 2005, the question was answered in the negative, and that was in a particular court case, but it failed to find a case of slavery. They didn't quite have the proper understanding. But as it got down there further, it clearly deprived personal autonomy. And so the general and legal, regardless of genuine legal ownership, it still had to do with conditions that were part of exercising possession and control. In other words, controlling personal autonomy. And if your personal autonomy is being deprived, then that is evidence of slavery in a proper sense. So as we jump down further, they had, again, that 26 convention referred to as chattel slavery has evolved. So chattel, paper slavery, has evolved to encompass various contemporary forms of slavery, which are also based on the exercise of any or all of the powers attaching to the right of ownership. So it really comes down to possession and control, the powers that are related to ownership. So you are owned if somebody else is controlling to the tune of possession or possessing through the mechanisms of control. And this is evident even if it's chattel slavery. So again, they basically wrote out that the law, the legal system, does not know of a right of ownership over a person. One person cannot own another person and be held up by the de jure. Although it seems to be happening through ownership, meaning control and possession, it seems to be happening in a de facto standard. So that 1926 convention speaks of a person over whom any or all of the powers, again, any or all of the powers attaching to the right of ownership are exercised. And that's the language that they prefer. They do not want you to basically use slavery as a terminology or the right of ownership. Instead, the language that they now prefer is this particular type of language. So in 2008, there was a relevant case on the definition of slavery. It's the Tang case, which was decided in the High Court of Australia. Had to do with some people that were bonded and sold. So we'll go ahead and take a look into that more. In other words, the court decided where the definition was applicable to cases of de jure slavery. So whether it applied in de facto situations where a person did not legally own another person, but instead exercised power in the ownership in a factual manner. So this was big. This was 2008. They moved and they've come along further from 1926, where you had to actually have de jure situations or status in order to be convicted or found negligent. Here, by the Tang case and a 2005 judgment of Saladian, I probably mispronounced that, the de facto situation where they didn't legally own the other, but instead were doing it by a de facto manner, were still recognized. And that's where we've moved to. A lot of people like to talk about how we're into a de facto situation instead of a de jure situation. And I think this is most evident here in contemporary slavery, a term of art, versus conditions like slavery or treatment like slavery. So there's the 1969 Vienna Convention on Law of Treaties. For the people that like to get back into treaties and holding the treaties of governance and persons, bodies politic, are relevant. The 1969 Vienna Convention on the Law of Treaties provides guidance on all things related to international agreements, including how treaties should be interpreted. So if you're getting involved with any of these treaties that are international, including the human trafficking, then the 1969 Vienna Convention is relevant because it gives guidance on how all treaties should be interpreted. A treaty should be interpreted in good faith. One should look to the ordinary meaning of the words. Now, many of us believe that we should be using ordinary meanings of words. In fact, forcing a person to use a different language is one of the conditions of one of the powers, if you will, that can be attached to the condition like slavery. And we saw that at the beginning. So whenever we're not being held to the ordinary meaning of a word, then in effect, the Vienna Convention on how treaties are supposed to be interpreted would be violated because it's supposed to be done in good faith. And if we're being forced into a different language, it's certainly not going to be in good faith. And if the ordinary meaning of the word is not being used and another is forcing you towards their terminology, well, then that would as well fit with conditions like slavery. So this goes in further throughout there on the Vienna Convention. So as we move forward, consider the ordinary meaning of the term status or condition. The legal standing, right? Again, this is a legal sense, which is not a term of art. So again, they've created a definition. The legal standing or position of a person as determined by his membership of some class of persons legally enjoying certain rights or subject to certain limitations. So if you're out there believing that you have an enjoyment of rights under the legal system, then to some degree, this is the meaning of status or condition. And it's a legal sense. So the status of a slave should no longer be recognized in the eye of the law. And that's because it's no longer a legal term. It is a term of art because the law will not allow one person to own another person. So condition eventually was used. So conditions like slavery came about as they continued to work through the Tang court and the other courts. It eventually, basically, the purpose and the evident purpose of the word condition was to cover slavery in de facto as well as de jure, because the condition, one of being possessed or controlled, is certainly viable in both a de jure situation where legally it would ownership is tantamount to possession or evidenced by possession or control, but this is the same thing then in a de facto situation. So again, in these conventions, the law does not know of a right of ownership over a person, but in fact the definition speaks of the exercise of the powers attaching to the right of ownership. So if you're showing that you have the power of the right of ownership, then in effect, you are breaking the contemporary aspect of condition because the law does no longer allow you to say that I'm being owned or that you're being owned. One does not need to own the thing, instead to exercise a power attaching to the right of ownership. So if you're acting like you own it, then that's sufficient. And again, not all of the ownership principles have to be exercised. Any of the ownership principles can be exercised. So since the object and purpose of the 1926 Slavery Convention is securing the complete suppression of slavery and in all of its forms. See, so they didn't want to just define the terms back then. They wanted to secure the complete suppression of slavery in all of its forms, meaning the powers attaching to. So the powers, again, would be control and possession, which are tantamount to demonstrating ownership. And again, the word de facto shows up down here, it being applicable also in situations of de facto ownership. So women were bonded through a debt. So this was the particular case again back in Tang, but you can go ahead and just take a look at this. These women were then bonded through a debt by their captors, and they gave them a particular amount that they supposedly owed. So if somebody is creating a debt for you and bonding you through that debt, or if your bond is some form of debt, or if you owe a debt and you had to place a bond, then to that degree, this court pointed out that the captor was the one doing it, and it was the fact that they created this bond through debt, which created the situation that was a condition like slavery. And their debt that was created by the captor was to be repaid through work. So this, in effect, is the same thing I think that's happening, say again, in a child support situation where a debt is being created against one of the parties. The party is then thrown in jail. And then in order to get out of jail, there is a bond created, an amount of debt that's owed, and it has to be paid through work. And in an international court is found in the Tang case, it is the party that's creating the debt, the party that's using force to capture and deliver the party like a possession into court, and then demanding that they work and pay it off is exactly the situation that was going on in this trafficking case. So now if you haven't consented, if you've consented to it, well then heck, that's theoretically all your own responsibility. But if you don't consent to this, then you have a condition like slavery because it's not voluntary. Or maybe it's not a condition like slavery. Well, it is a condition like slavery because even the de facto and the serfdom and the other servitudes that exist fall within the conditions that are like slavery. And again, it doesn't have to be all of them. It could be any of them. So any time where, again, man or woman are bonded through a debt, and then that debt has to be paid through work, it could be basically considered a condition like slavery. And so here they get into a little detail and actually further describe the exact situation, which also could be similar to your labor, your wages as you work, and you only get to take home a partial portion of what you may earn. So it would have been a pitiful effort if they only dealt with questions of legal status. So, to sit here and go, the law and the letter of the law says this, and we're only going to look at legal things, even they admit that just looking at what's written in the letter of the law would be a pitiful effort. In its application to de facto conditions as distinct from the de jure status of slavery. So it's been recognized internationally that don't give me the letter of the law on these situations about whether it's a condition like slavery, or because it would be pitiful in that case. Because looking at the de facto condition of slavery is how it's being accomplished today. Because in the de jure system, there is no longer such thing as slavery. So not necessarily all of those powers, but any of them. See, they write that in there. Not necessarily all of the powers, but any or all. So one would qualify as any. So again, back to the debt bonding. That for the psychological exhaustion. How about the possession or the control or the threats and coercion and duress? So for the duration of the contracts, the owners had the capacity to use the complainants. Now, is that what's happening when one person comes and complains to a court, and then during the duration of the contract, the owner has the capacity to use the complainants? I think that's the definition of parens patriae, which in the clip I shared the other day on the role of the Michigan Attorney General and Consumer and Environmental Protections, the bar even admits that they don't have the ability or the power to come down on behalf of one of the individuals in the state to collect for another, yet they wanted to circumvent that. And this, I think, is also shown that for the duration of the contract, the owners had a capacity to use the complainants. So it's important not to debase the currency of language. This is something the court actually states, which I find to be oxymoronic, ironic. It's probably one of the best quotes I've seen in a long time, considering they're talking, and we just got done with pages about terms of art versus and legal currency in the terms of art versus the term of law. It is important not to debase the currency of language. If you and I are not communicating on the same terms, if the terms can't have the same value for me as they do for you, then the term that I offer to you is debased based on your understanding and vice versa. And here, the whole structure is about terminology and somehow coining a term. So it is important not to debase the currency of language. Wow. Then they turn around and get into the English meaning that is captured by the expression dominion over the subject matter. So this was a couple of judges basically talking and considering the notion of ownership. And it must be read as conveying the ordinary English meaning, which is captured by the expression dominion over the subject matter. So, dominion, subject matter. I mean, this is exactly what happens when people are basically asking to have something dismissed for failure to state a claim. The claim can only be dismissed if the court doesn't have subject matter jurisdiction or personal jurisdiction. And here, dominion over subject matter, based on a basic English meaning. But again, debasing the language or the currency of language is exactly what these two judges are arguing over the meaning. And so it's recognized in law as the powers over the subject matter. So who is the subject that is being considered as the matter? I'll tell you what, when I was bonded out and received a bond to get out of jail, they brought in there and they demanded that you give DNA. And then they had demanded that you give fingerprints. And then they gave you a spot where you had to sign. And it said specifically on the title for the box where your signature went, it said specifically subject's signature. And we know that only royalty or a sovereign has subjects. So it's interesting here that somehow, some way, by using terms of art and legal terms, somehow there is a dominion over the subject matter, and the subject can be he who signed on a dotted line. So again, recognized in law as the powers over subjects, subject matter. So again, down here, stating that possession, like ownership, refers to a state in which there is a complete subjection of the other by the first person. This is in documentation now, but this is also what's happening in a de facto situation, yet somehow being carried out as a de jure activity. So possession, like ownership, refers to a state in which the complete subjection of the other by the first person. And again, person in a legal definition, not our common vernacular where you think that you and I are a person when we're talking in basic language, but person actually is a term of law. So, and in that term of law, a person is a corporation, a body's politic. And you can find court cases where it says that the government is a person for the status of suit in the legal system. So here, notice of ownership and of possession can be understood as an exercise of power over that person that does not depend upon the assent of the person concerned. So in other words, if you don't consent, if you're not part of it, and you don't want to be part of it, the notion of ownership as possession is understood as an exercise of power over someone that isn't choosing to be part of it. Asking whether there was a requisite dominion over a person, the subjection of that person, it will be relevant to ask whether that person concerned was deprived of freedom of choice in some relevant aspect. So freedom of choice is huge. And if you're being deprived of your freedom of choice, then it basically is some form of possession and control. And it is tantamount to conditions like slavery. Now, see, we get down here, in the next paragraph, involuntary servitude in the United States. So they've gone through other terminology again. Involuntary servitude would be the violation of your freedom of choice. And in the United States, they've got all kinds of insights into this area and talked about it and what type of freedoms a person's supposed to have. And if you're not getting those freedoms, if your freedom of choice isn't there and you're being deprived of it, then it's basically subjugation of that person. So in particular, ask whether a complainant was deprived of choice may assist in revealing whether that the accused, which would be the enslaver, what they did was exercise over that person a power attaching to the right of ownership. So we don't say slavery anymore. We say whether or not someone complaining of conditions like slavery was deprived of a choice that may help show whether the enslaver did exercise a power of control or possession, or any of those, not all, but any of those things that would show some form of ownership. So it gets to the heart of the normative understanding of slavery. So again, since slavery no longer exists, it's kind of like collusion. And so therefore, conditions like slavery, which we call human trafficking now, is what they're talking about. So that's the heart of the normative understanding that's going on. And they dealt with that in Tang, beyond the majority judgment in Tang, as to the application of the definition of slavery in a contemporary setting. So Tang was a while ago, and they've had to continue working it further, and we basically now look at what you're going through if it's control or possession, through coercion, fraud, actual possession, threats of violence, forcing another language, controlling your religion, or being able to exchange in a transaction, humans, being able to create bonds and debts and force another person to work to pay it all off while exercising control over them. These are all conditions that are said now to speak to the heart of the normative understanding of slavery. So the final point is worth emphasizing. The definition of slavery slipped further and further into obscurity so that its applicability was near naught. So there was a time in a period where it was taken out of the limelight, and nobody considered it in any way whatsoever, and the applicability of the situation was pretty much nil. But that's not the case anymore, and I would think that even the fact that it's being brought to your attention in this clip shows that it must be some concern beyond nil. And so that's, again, back to the Bellagio Harvard guidelines. So they had a slavery convention, of course, and worked on the definition of slavery, and it was developed in the context of the League of Nations. And at that point in time, it was a European colonialist club. And what's neat, too, is they were seeking to end slavery beyond their own membership. So we're talking about Europeans in a League of Nations that were a club of colonialists. So those organizations that had colonies, and they wanted to end slavery beyond their membership, which means what beyond the membership means within their membership, it still retains such conditions. And so leaving it intact within the colonies is exactly what they intended. So don't let anybody else slave, just us. And so granting general supervision over the executions of agreements with regard to the traffic in women and children. So even amongst all of these different things, they still said that it's important for some person, some League of Nations of colonialist clubs are still keeping general supervision over the execution of agreements with regard to the traffic in women and children. It's as if they're choosing them as a specific point to maintain a status and a standing to continue to exercise their power of control and possession. So this type of guideline here would be why, again, a man has potentially no right to his own offspring or woman if it was illegitimate, because according to international treaties, these organizations are still protecting women and children. And so they're regarding women and children, and they're managing any executions of agreements, which would be marriage license or agreements where offspring were produced, and there wasn't an agreement prior. So let's get back to the right spot. So what we have left are the applicable, what's applicable still to its definition, sets out the following definition, that slave trade includes all acts involved in the capture, acquisition, or disposal of a person. Now, what their intent is, they want to say to reduce them to slavery, but slavery, again, is no longer written into legislation. So you can't use that term by their own definition within this doctrine. So you can drop that portion and say it has to do with the acts involved in the capture, acquisition, or disposal of a person. So these things are certainly happening today. And again, here they say any or all of the powers. The definition of slavery as the maintenance of a private individual of rights over another person of the same nature as the rights which an individual can have over things. So if one person is managing, if you will, a private individual's rights, or taking private individual rights and exercising them over another person who should have the same nature of rights, and they're doing that as if that individual is a thing, then that falls into our definition of slavery. So here they get into serfdom and all these other things, and they tell you right here, realize that the status of serfdom, which was one of these other servitudes that existed, is a condition analogous to slavery. And again, since slavery is no longer a term that you can be charged with because the law will not allow legal ownership or de jure ownership of another, they've moved to the de facto understandings, and all we need is conditions similar or amounting to slavery. Serfdom is the same thing. So they had a committee of experts on slavery, and more explicitly in regard to its considerations of debt slavery. So debt slavery, like serfdom, is another servitude where somebody doesn't consent or that a debt is created. And again, Michigan has debtor's prison is unconstitutional. So debt slavery is only a temporary form where, in effect, they think that your slavery ends as soon as the debt is repaid. So that's why they don't want to get into debt slavery being some form of slavery, because theoretically it's going to end. But in practice, the condition in which the debt slave lives are often of the nature that repayment is an impossibility, and the debtor is therefore a slave for life. Now, this is kind of interesting because the word pay means, to give something of value for an obligation. And there are court cases out there that basically point out that the Federal Reserve note does not aggregate to payment, only discharge. Federal Reserve note is legal tender, but it's also a bill. It's an IOU. And on top of that, because it's an IOU, you cannot pay a debt with a debt instrument. So repayment is impossible even in the legal system of the United States by their own terminology and some of their own court cases. But on top of that, if you say a man was given a debt, that man would have to go into the system and not only gain debt instruments to discharge it, but on top of that, just for working to gain those things, they become subject to all kinds of taxations and costs associated with it, to where it's a perpetual life within the system. So it's interesting that they even admit right there that in debt slavery and debtor's servitude, it's basically impossible for the debtor to pay off their debt, and they become a slave for life. There are cases in which debt is hereditary, and after the death of the parent, it is transmitted to the children and the children's children. Now, when I was in 7th grade, the national debt was $2 trillion, and now my poor kids or grandchildren, and as I leave, are now responsible for almost a $30 trillion debt. So the United States practices this hereditary debt and carries the burden across all of the people that they're basically putting into debt slavery on behalf of their legal tender. So whatever form it may take in different countries, unless any or all again of these powers are exercised by the master. So these, again, debt slavery is one of those forms that it takes, depending on the country. If there is any or all of the powers, so we can even drop the all. So if there are any of the powers that surround ownership are being exercised by the master, no matter what form it takes, then it's some form of condition like slavery. So to encompass lesser servitudes or types of human exploitation falls within the ordinary meaning. And so the term servitude was dropped. Go figure, they dropped the term servitude, and the instrument that they created at this particular convention in 1956 was Supplementary Convention on the Abolition of Slavery, the Slave Trade, and Institutions and Practices Similar to Slavery. So again, we've gotten rid of the word slavery, and they've begun all of these other terms in order, and one of the terms that they got was institutions. And we all know what institutions are. They're the ones that are basically mechanisms, forms, and processes that continue to produce situations or conditions similar to slavery. So even institutions or practices similar to slavery eventually got dropped to a shorter form, which is practices similar to slavery. So if it was not slavery, then at least servitude in the language, it's a practice similar to slavery. And again, since we only have this status left, and we no longer have de jure slavery, so therefore it's a colluding term, we have to use the proper terminology in order to demonstrate conditions like slavery. So methods traditionally used by the colonialist must be regarded as practices similar to slavery. So that's, again, consider whether or not you're living in an institution or that basically traditionally used by the colonist to practice conditions similar to slavery or practices similar to slavery. So having sowed confusion by this nomenclature, any momentum that might have been generated in addressing the issues of slavery was lost from 1966 onwards. So again, here, all of these conventions and treaties and conversations on basically debasing the currency of language, all they did was sow confusion and take away the momentum that might have been generated in addressing what we're dealing with today. And I've been dealing with from 1966 and onwards, as it points out there, but I'd say this has been going on since scriptural times. By its tenure, it had overseen the collapse of the applicability of slavery at the international level. So, you know, a lot of us have been focusing at the federal level as if that's our main concern, and the federal level is basically working at an international level, and the international level, through organizations that we've become aware of, like the World Economic Forum, is where slavery seems to have the applicability of all of this has collapsed. And so what we're dealing with now is we have focused and recognized that the local level is where the people are. That's where the strength of the power is. And so the local level helps prop the state level up. The state level created the federal level, and the federal level is working at an international level. And the World Economic Forum is basically trying to come from the international level down to the local level in order to bring about urban transformation and various securities groups. Here it even says within a 2006 conference of a UN working group, the United Nations working group, that at the international level, slavery and upholding such understanding through confusion in the nomenclature has basically collapsed. So it's almost as if they set up to do it from the international level and then reach all the way down to the local level and continue basically under the heading of contemporary forms of slavery. And so under that heading of contemporary forms of slavery, they considered a number of social ills, including detained individuals. So on behalf of the children, think about it. If you had a child that was yours, somebody else detaining your child would be an international violation, a federal violation, a state violation, and a local violation, because the only one granted the opportunity to detain their own offspring would be the parents who were granted the authority by creation over that offspring. So they've looked at all of these and various other reasons, but again, focusing on the women and the children in order to bring about the safeguards and the protection that they think are appropriate. So history repeated itself, though, and this to me also shows where the power is and where the people have the power, especially at the local level. And they show right here that just as Quaker activism and Anglican evangelism laid the foundation, it would be the first they basically ended the first transatlantic slave trade, which led to the end of the slave trade on the land. And so too did the religious right in the United States. So right here, about the only opportunity that we see as a way to circumvent, or sorry, not even circumvent, but to actually end slavery in conditions like slavery and basically have a revival is founded in the faith. So there was a dominance allowed it to force. So a government's dominance, a person's dominance, allowed it to force a right to search, effectively authorizing it to police and control commerce. This is an area that they were basically dealing with, and the people got tired of it, and this was part of one of the 2000 Victims Traffic and Violence Protection Act. So just as some power had a dominance, which allowed it to force a right to search, which basically effectively authorized it to police and control commerce, created part of the problem. And so down here, the World Bank and the International Monetary Fund is basically part of how the United States has a dominance that allows it to force and effectively police through controlling commerce. So the United States is enforcing international criminal law in the guise of international instrument. I mean, it says it right in here. I mean, you can take out the extra words that get in the way, so it makes perfect sense. The United States, and we see right here, the United States uses the International Monetary Fund and the World Bank. The United States is enforcing international criminal law in the guise of an international instrument. And so, again, recognizing back that they just said that through the seeds of confusion, the collapse of the applicability of slavery at the international level, and here the United States is using the guise of an international instrument to enforce international criminal law. So here, as we keep moving forward and trying to define what all this stuff, now we've moved into trafficking in persons. And so they give you a nice definition. It shall mean the recruitment, the transportation. Controlling the transport of persons is considered trafficking. The transfer of persons is part of trafficking. So again, if one parent can be dispossessed of their child and basically transferred to another. If the court can transfer your child out of your possession and dispossess you and give control of that child to a government agency like Child Protective Services, then that would be transfer. Harboring or receipt of persons, a bill of lading, a certificate of personage. Trafficking shall also mean by means of threat or use of force or other forms of coercion. If by fraud or deception or abuse of power, these are all trafficking persons. Or the giving or receiving of payments or benefits to achieve the consent of a person. See, giving or receiving payments or benefits to receive the consent of a person, same thing as coercing or incarcerating or pointing the gun at or even taking the children of a man or threatening to do such things. This is exactly what happens with CPS, is they force you through threat into what they call a voluntary contract. Where is a voluntary contract when you're being forced into the contract? How can you still use the term voluntary? But if they're using the consent of a person having control over another person for the purpose of exploitation. Exploit, when you're mining, you're exploiting a resource in order to gain those resources. And so exploitation is not always a bad thing unless, of course, you don't have the right to mine there. So exploitation includes at a minimum the exploitation of prostitution, of other forms of sexual exploitation, but also forced labor or services. If you're being forced into giving labor or services, it is a form of trafficking in persons. And if it's done through coercion, by forcing consent, by having control over another person, like your offspring, or if it's by giving benefits and payments to the person who comes to the court system by over another individual, like in parens patriae, as expressed in that prior clip, then these are all things that was known that it shouldn't be done, yet it's still being done. Forced labor. These are slavery or practices similar to slavery. So the dominant position of the United States holds through informal empire. So, I mean, right there, they even put it right in there. I mean, they describe the United States as an informal empire. Now, interesting thing about Rome, if you know about an overview or an upper level view of Rome, Rome spent almost 1,000 years as a republic, and then it spent the rest of its time as an empire. So right here in the very documentation written here, the United States is basically an informal empire. And we know that from prior documents that it is tied to the International Monetary Fund and the World Bank, where it is the enforcer. So we'll go ahead and consider whether or not you think the United States is actually a republic any longer, or if, as admitted here, it's actually an informal empire. So, and they require states to pass legislation. So we have that happening within the United States, but then the United States is also doing that at an international level as an enforcer on behalf of the World Bank and their International Monetary Fund. At least that's what I'm getting as I read through this. This is, again, conclusion. Conclusion is not fact. I can't make what these words mean to me a fact. The fact is, this document exists. I'm showing you the words. What you conclude them to mean to you goes back to the value of the language of currency, the currency of language. And I'm not trying to debase it by sharing my considerations, my conclusions as to what this means, but I wanted to share that with you as I looked at the fact that these words are written. So here they got the Roman statute, was again part of these things you can look at. There was a Cunerac case that had to deal where they went to an appeals chambers, but here the word any or all show up again. So every single time, they never say that all of the powers attaching to the right of ownership have to exist. It's any of them. So out of all of these powers that I've shared in trafficking of persons, if any of these exist, any, just one of them qualifies as any, then you probably have conditions like slavery. So any or all shows up on the next page. So elements of the crimes coming out of this Rome statutes and all these other international criminal courts and conventions based on their legislation, this one 2002, elements of the crimes set out the following. The perpetrator exercised any of the powers attaching to the right of ownership over one or more persons. That's it. Now they get into an example such as, so the perpetrator exercised any of the powers attaching to the right of ownership over one or more persons. Such as, so it could be only one person that they exercise it over, and it can be any of the particular elements. So any of the elements over any one person covers it. And so we can look at the examples now, and these are just such as by purchasing, selling, lending, or bartering such a person or persons, or by imposing on them a similar deprivation of liberty. So if you can find one spot where a person, again, legally defined as a corporation, a body's politic, a corporation, association, a partnership, a joint venture, these things have exercised any over a singular, then these are elements of the crime as set out by their own criminal courts, international criminal courts. So this provision brings us full circle as it pertains to the powers attaching to the right of ownership, which is where we started at the very beginning of the chapter. You know, the fundamental element of slavery. Fundamental element of slavery, which again is a legal term no longer having any bearing, is the loss of personal liberty of the victim, where it reaches the threshold of control tantamount to possession. So just as they close this thing out, they got trafficking protocols and Rome statutes and all kinds of international things from the international courts and conventions. But they do basically point out the United States tying World Bank. So the World Bank is, again, something that is internationally, fundamentally tied to the United States. And these words come in there. And again, I've only highlighted certain ones. But the ICC looking into issues of systematic enslavement within a country and the United States, tying World Bank assistance to the suppression of trafficking of persons. So not only are they using this World Bank in the United States to suppress it, but by suppressing it, these are the ones that are defining it and somehow helping it to slip into obscurity, debasing the currency of language, and giving us this confusion that allows the colonialist mantra to continue going forward. So they got a slavery from considered the definition, the genesis of definition of slavery from the League of Nations through the United Nations, and they work it all the way up to the Tang judgment, and through all of these, they got legal parameters, the Bellagio-Harvard guideline, the legal parameters of slavery, which flesh out the exercise of powers attaching to the right of ownership in situations of slavery, again, conditions like slavery. The fundamental understanding of the definition of slavery, then, is the controlling of another person as one would possess a thing. So I could take my fork and go put it in a drawer, and that is the possession of a thing. And if a man is being taken and being put into a cell, then he is being possessed and controlled like a thing. And if he hasn't consented to this system where the currency of language has been debased and he can't even understand it, or it's done by fraud or coercion or threat, well then how can you not consider some of these things based on this definition that's happening at an international level? How can you not find that you might be living in a condition like slavery? So finally, the powers attaching to the right of ownership will include the buying, the selling, the use, management, profit, transfer, or even the destruction of a person. So again, it doesn't have to be all. It can be any of these. Any power attaching to the right of ownership will include buying, selling, use, management, profit off of, transfer, or even the destruction of a person. You know, destruction of a person, I mean, contemplate that within states still carrying the death penalty. Transfer, think about that happening within the family court system. Profit, think about that within your income tax system. Management, think about that in any of the contracts that you might be bonded into and forced into. Use certainly happens within eminent domain. Selling and buying, people have talked about the birth certificates and how those things are bought and sold on the market and have documented such things. So there are all kinds of ways where people have shared ideas to where these basic common language terms have also been turned into a legal de jure term and used in all kinds of things, and no longer have the same value that we might contemplate them in a de facto standing. So, you know, kind of bouncing through the footnotes. So all of this does have footnotes. One of them down here I thought was interesting was one person would have dominion over that of the other person. That's most certainly the case nowadays. The complete subjection of that other person to the will of the first. So again, person being a legal term, not a common language term. Again, based on the confusion happening within the language. So whether you look at the word person as a common term or whether you recognize it's being used as a legal term, would have an application under fraud and deception. So exercise would not depend upon the assent of the person over whom the powers are exercised. So if there is one not consenting, or if you can't find evidence of consent or assent, you know, the exercise doesn't always have to depend upon the assent of the person, because with fraud and deception and international agreements that allow an organization or a person to force others into statutes and legislation certainly would not be upon the assent. So that's kind of the end of this particular document. I thank you for sitting through this long presentation on this document that you can find online called Contemporary Slavery and Its Definition in Law. This name would also help. I don't know whether it's pronounced French or in English, so I'll save from that. So thanks again for taking the time to take a look, and hope to get another one out for you soon.